Good morning. We're calling the Assembly Appropriations Committee July 15th hearing to order. Don't have enough for a quorum, so we'll start off as a subcommittee. First up is Senator Jackson. Senator, you have 4 bills with us. 3 bills are on suspense, and SB 570 enjoys a due pass recommendation. How would you like to proceed?
Why don't I start with that one and work my way from there? Good morning, Mr. Chair and members. This is SB 570 that I would like to present. This is a bill that would improve the readability and clarity of data breach notices sent to California residents when the security of their personal information is compromised in a data breach. Now, basically, existing law requires data breach notifications to be made in the most expedient time possible without unreasonable delay, and specifies certain information that must be included in these notices. The law provides that breach notifications must be written in plain language, but is otherwise silent about how the information should be presented or organized. If you have had similar bad luck as I have, you have had your data breached or potentially breached at least once or twice, given how prevalent this problem is becoming. And if you've tried to read those data breach notices, they are virtually incomprehensible. All this bill does is it takes what the law now requires that information include and puts it into a legible format, which is the reason why I believe that the costs are estimated to be minor and affordable. So basically, this bill simply improves the readability of breach notices by simplifying and standardizing how entities present that information about a breach to those affected Californians. It directs the information currently required under existing language to be presented in plain language. So what we have done is we have grouped this under 5 headings: what happened, what information was involved, what we are doing, meaning the company, what you can do, meaning the individual, and then for more information, please contact whoever it is. These changes to the data breach law will help ensure that critical information is communicated effectively to California residents, thus empowering them, us, me, you, to take appropriate steps to protect after a data breach has occurred. I'm proud to say that after working with industry stakeholders, recent amendments to the bill have removed all opposition, and these recent amendments essentially just eliminated a page limitation. We were hoping to put it all on one page, but this will definitely assure that we limit the number of pages to provide that very simple, direct information. And with that, we have, I believe, the Attorney General's office here to testify in support of the bill and answer any technical questions you might have. I thank you for your consideration, and I respectfully ask for your aye vote.
Thank you, Senator. We're going to call the roll.
Gomez.
Here.
Bigelow.
Here.
Bloom. Bonta. Calderon. Chang. Here. Daly. Here. Eggman. Gallagher. Garcia. Here. Holden. Jones. Here. Quirk.
Here.
Rendon. Here. Wagner. Weber. Wood.
Here.
We have quorum.
Thank you. We have Joanne McNabb from the California Attorney General's office.
Move the bill.
We have a motion, a second. Please continue.
I'm the Director of Privacy Education and Policy in the Attorney General's office. We do annual reports on data breaches, and one of the findings that we have made repeatedly is that the breaches are very hard, the notices are very hard to understand. Obviously, that's the purpose of the notice, to notify people that they are at risk and tell them how they can protect themselves. This bill would make it easier for people to understand what the notice says, and therefore would reduce the negative impact on them. Thank you.
Thank you so much. Any other witnesses in support? Individuals from the public in support? Witnesses in opposition? Individuals from the public in opposition. Department of Finance.
Chris Leaf, Department of Finance. Finance is neutral on this bill. The costs are minimal.
Thank you so much. Questions or comments from the committee members? Seeing none, would you like to close, Senator?
Just ask for your aye vote.
Thank you so much. We have a motion from Mr. Quirk, a second by Wood. This bill is out on an A roll call.
Thank you very much, Mr. Chair and members. Next, I'd like to present file item 122. This is a very, very modest, but I believe practical measure designed to bring the California Environmental Quality Act, CEQA, into the 21st century. It will save time and money and make CEQA more efficient and accessible to the public. This bill does two things. First, it explicitly authorizes the lead agency, at the request of the project applicant, to prepare the record of proceedings during the CEQA process. While this provision, again, is optional, it could save certain project proponents a great deal of time and money in situations where the project proponent anticipates facing a CEQA legal challenge down the road and when the process is over. We did an analysis. We sent out to all the major stakeholders a request for a response on what they felt were some of the most significant problems associated with CEQA. We heard from most, or I would say a great number of the general stakeholders in the CEQA process, that delay was one of the most significant problems for project applicants, because the money that they receive to do the project costs money while it waits without the project being completed or approved, I should say. And then with the litigation and so forth, the time it takes to prepare the CEQA record after that process is completed delays a project from anywhere to 6 months to a year just to get the record prepared. This bill will allow the applicant to, and 99 times out of 100, they know when this project is going to be subject to litigation. It allows them to get that record prepared contemporaneous with the whole process so that they save that 6 to 12 month period of time. Not a barn burner idea, but one that clearly benefits everyone in the process. The second issue is that this bill will expand the online CEQA database currently operated by the Governor's Office of Planning and Research to include copies of all CEQA documents, forming a true statewide CEQA clearinghouse. Again, right now, the CEQA process is largely paper-based. Information that is posted online is often buried deep within agency or project proponent websites. This provision will again bring CEQA into the 21st century and expedite the process. Again, that's the focus of this bill, by increasing transparency and providing the public with an easy-to-use, universal point of entry into the CEQA process. The analysis estimates one-time costs of about $220,000 to get the CEQA database up and running, and then ongoing costs of about $54,000 to maintain it. However, a recent report by the California Research Bureau states that any costs for the updated database would be offset, because the updated database could save state agencies anywhere between $250,000 and $500,000 annually. This is a common sense measure that will help expedite the CEQA process, provide transparency, save money, while still protecting the integrity of CEQA. The bill is supported by the Association of Environmental Professionals, the American Planning Association, California Labor Fed, the State Building and Construction Trades Council, California League of Conservation Voters, and others. And I have with me today witnesses in support, and I recognize that this is a candidate for suspense, but again, this is actually going to be a cost savings measure, and I would respectfully ask for your aye vote.
Thank you so much. Your witness, please.
Mr. Chair, members, Sarah Flocks, the California Labor Federation, in support. This is a cost-effective way to modernize CEQA and bring it into the 21st century, as the author said, while at the same time maintaining all of the very important protections for our environment and for the public. And so we ask for your support.
Thank you so much.
Good morning, Mr. Chairman, members of the committee. Paul Gonzalez representing the city of Camarillo. I think the senator did a fantastic job of summarizing the bill. We find it to be very helpful for us, and we ask for your support.
Thank you so much. Any other witnesses in support, individuals from the public in support?
Matt Kloppenstein with the Association of Environmental Professionals in support.
Thank you.
Sandra Spellisy on behalf of the Planning and Conservation League in support.
Thank you so much.
Sandy George for the American Planning Association in support.
Thank you. Witnesses in opposition, individuals from the public in opposition, Department of Finance.
According to the Office of Planning and Research, this bill would have approximately $220,000 of one-time costs and ongoing costs of approximately $58,000 a year. We also note that expanding the database could result in savings to various state agencies.
Thank you so much. Questions or comments from the committee members? Let's just also, this is not a debate to debate CEQA as a whole, but to debate this bill. Any questions or comments? Nope. Seeing none, would you like to close?
Would respectfully ask for your aye vote.
Well, it's on suspense. This, and when we'll take it into due consideration when we take up the suspense file.
Thank you very much.
Thank you.
The next item is SB 221. This is I think, a very helpful way to address our wounded veterans as they transition to work. And this is a problem that has existed for some time and continues to exist as our veterans come home from deployment and want to get back in the workforce. So if I may briefly present this, we're calling this the California Wounded Warriors Transitional Leave Act. And this bill would provide transitional sick leave to disabled veterans just entering the state workforce so they can attend to their medical and VA appointments without having to take unpaid leave. This bill will limit state costs by ensuring these veterans are taking full advantage of their federal VA benefits rather than relying solely on state benefits. There are also significant aspects to this bill that limit costs. It is limited to veterans who are hired on or after January 1, 2016, and it is also limited to those who are 30% or more disabled from a military service-related disability. In addition, the 96 hours of sick leave offered in this bill will be forfeited after a year's time, if not used, when these veterans will have accrued sufficient sick leave time on their own, thus ensuring it doesn't result in higher retirement calculations. Now, presenting this in that form really is difficult for me, because the goal here is to give these veterans a chance to continue getting the care and treatment they need as a result of their experience fighting for our country. But the fact is, we're here talking about appropriations, and so if you would indulge me in looking at the costs of this, but this bill goes way beyond the costs. It's a modest measure that will result in a more productive state workforce and will show our continued commitment to the men and women who have served our country. And with that, should the bill come off the suspense file, I respectfully ask for your aye vote.
Thank you so much. Your witness in support.
Good morning. Dana Nickel with Pete Conity and Associates. The following clients are in support: the American Legion, AMVETS, California Association of County Veteran Service Officers, the California State Commanders Veterans Council, the Military Officers Association of America, the Veterans of Foreign Wars, and the Vietnam Veterans of America. Last year, California vets received almost $600 in monetary assistance alone. VA health benefits exceed this amount. There's a lot of money out there from the federal government available for veterans, and it really behooves the state to let the vets get this. Also, if the veterans do not use their VA benefits, they often fall back on state or county programs. Also, VA offices are dispersed all over the state, but a park ranger in Delaware County might need to drive to Redding to a VA clinic, so this time could really be well used. Thank you.
Thank you. Thank you so much. Any other witnesses in support? Individuals from the public in support? Witnesses in opposition? Individuals from the public in opposition? Department of Finance?
This bill results in unknown payroll implementation costs.
Thank you so much. Would you like to close?
Again, I think this is an important statement to our vets. I think it will ultimately save us money. The human costs associated with trying to transition back from military service into state workforce service, I think, warrants this measure. And should this come off, I would ask that it come off suspense or be available for passage at this point in time. I'd ask for your aye vote.
Thank you so much. The bill's on suspense. We'll take it up in due course. Next bill.
Thank you. The final bill, Mr. Chair and members, is SB 612. It is also a suspense candidate, but I'd like to present briefly on the bill. This measure deals with CUPAs, which is a very exciting topic. These are the Certified Unified Program Agencies. It is a very technical bill that updates and clarifies health and safety code sections dealing with business plans for hazardous wastes. Thus the name CUPAs. They're charged with overseeing these processes. And this year, SB 612 builds on efforts of the previous past 2 years, where we want to bring clarity and consistency on some of the more problematic issues that have necessitated additional conversations with stakeholders, including issues that have arisen with some of the other programs CUPAs are charged with overseeing, such programs as inspecting and regulating the used oil collection centers, increasing environmental protections by closing gaps and harmonizing the relationships between above-ground petroleum storage, the Petroleum Storage Act, the Underground Storage Tank Act, and the Hazardous Waste Control Act, clarifying the duties of owners, clarifying the responsibilities under the Accidental Release Prevention Program, and requiring DTSC to provide program guidance on hazardous waste counting. Again, not exactly exciting, but really important in terms of addressing hazardous waste, so that both the industries and the regulators have come together in this third of 3 bills to really update and advance these programs to the benefit of all parties concerned and the public health, safety, and environment as well. As the analysis indicates, the State Fire Marshal has identified minimal costs of $150,000 for the first year and $100,000 ongoing for the State Fire Marshal to provide the additional oversight to the above-ground petroleum storage program. I have with me today witnesses who can help answer any questions you might have, and a note that there is no opposition to this bill.
Thank you so much.
Mr. Chair and members, Justin Malone for the Local Environmental Health and the Coopers here. Again, thanks to the Chair for doing this. It's been a yeoman's effort. Not exactly stimulating work, but really necessary work, as you can see from the folks that have supported this bill. No opposition. We haven't compromised public health and safety, but we have clarified the code. And we strongly believe, as the regulators, if the code is clear, it's easy to comply with. And that's really what we have been trying to do. So we have tremendous support, and I'm particularly pleased to be able to offer support of SEEB. That's the regulated community, and it's not often that I can do that. They are very, very happy with the way the last 3 bills have panned out. And we do believe that what minor costs there are should really be absorbable within the broader program, and as a result, we urge your vote.
Thank you, Mr. Chair. Russell Nowak on behalf of the California Fire Chiefs Association. We've long participated as a stakeholder in these discussions and wholeheartedly support the bill on behalf of the whole fire service community. Thank you.
Thank you so much. Would you like to close?
Just simply...
hold on. I guess I have to...
I don't think there's any opposition, but
opposition, individuals from the public in opposition, Department of Finance.
CAL FIRE estimates $100,000 of ongoing costs and $50,000 of one-time costs. We estimate minor and absorbable costs to Department of Toxic Substances Control, the State Water Resources Control Board, and the California Environmental Protection Agency.
Questions or comments from the committee members? Seeing none. Well, thank you for bringing this bill forward. You know, just $150,000 just hit the mark of the suspense threshold. So there we go.
Well,
questions or comments? Would you like to close?
Just hope that this comes off suspense. I'd ask for your aye vote.
Thank you so much. Senator Monning. There's 2 bills, right? Senator Monning, you have 2 bills on suspense, SB 315 and SB 344, and then you have 1 on consent with amendments, SB 489. I figured you were here to present on your suspense bills, but go ahead.
Yes, thank you, Mr. Chair, members. I wanted to make just brief presentations on starting with SB 315, and then I'll follow with SB 344. Senate Bill 315 authorizes the California Health Facilities Financing Authority, or CHAFA, to start a second California Health Access Model Program, or CHAMP 2 grant program. The funds used will not adversely impact the existing CHAFA loan program, and CHAFA has experience from the first CHAMP grant program that will be applied to this. The grants are expected to increase health access and improve clinical outcomes for vulnerable populations, and as a result, achieve cost savings in our healthcare system. Members sponsoring this bill is State Treasurer John Cheng, and here to answer any questions is Nick Giolino from the Treasurer's Office, also Ronald Washington from CHAFA if there's any technical questions. Thank you. With the permission of the Chair, would present the witness in support.
Please begin.
Good afternoon, Chair and members. My name is Nick.
Your mic, please.
Sorry, better?
Yep.
Good afternoon, Chair and members. My name is Nick Lino on behalf of State Treasurer John Chung, the sponsor of SB 315. In 2012, the legislature supported the development of innovative healthcare solutions for our state's most vulnerable through the CHAMP program. As the analysis indicates, CHAFA recently commissioned a financial analysis of the HELP Loan Fund and determined that the fund's ability to continue providing support for loans would not be negatively impacted by this program. The Treasurer respectfully requests your support in improving the quality and decreasing the cost of health care for the people of California. Thank you very much for your consideration, and as the Senator mentioned, Ronald Washington of CHAFA has made himself available for any technical questions.
Thank you so much. Any other witnesses in support? Individuals from the public in support, witnesses in opposition, individuals from the public in opposition, Department of Finance.
Finance opposes this bill because it prematurely creates a second CHAMP grant program. The initial program was passed into law in 2012. The first grant was awarded in July 2014, and the evaluation of the grant program will not be completed until a year from now. Allowing the evaluation to be completed before creating a second program will ensure project effectiveness.
Thank you so much. Questions or comments from the committee members? Seeing none, would you like to close?
Yeah, just briefly, just to comment on that. There's been preliminary evaluation of the first program. The second program would consider other grant applications. They wouldn't necessarily be based on the performance of the first grant. They would be independently evaluated. The criteria is reducing adverse health impacts in vulnerable populations. So at the appropriate time, I would encourage an aye vote. Thank you, Mr. Chair and members.
Thank you so much. Your next bill, please.
Yes, SB 344. Thank you both. In an effort to enhance commercial driver safety and save lives, Senate Bill 344 requires new drivers seeking a commercial driver's license or CDL to complete a training course of instruction before being issued a commercial driver's license. SB 344 also removes the Bureau for Private Post-Secondary Education exemption for institutions offering certified CDL courses, thereby stopping the proliferation of what have been called diploma mills. While I understand this is a candidate for suspense, I'd like to note that the costs identified in the analysis are non-general fund, and both the Motor Vehicle Account and Private Post-Secondary Education Administration Fund are supported by programmatic fees. We're also in discussions with the DMV to align timelines for the state to implement federal regulations for commercial driver training so as not to require duplicative state regulations and allow the state to draw down on federal funds. Furthermore, it's not my intent to conflict with pending federal requirements, and it should also be noted that I've already delayed the bill's start date by 1 year with this intent. SB 344 will prepare California's implementation on the most basic component of these regulations, and we should not take the stance of waiting on the federal government to act to pass a bill, especially when it's been more than 20 years since Congress' initial law to require the training. By ensuring that commercial drivers are receiving an adequate standard of training, we will reduce the risk of tragic and fatal accidents that will ultimately benefit public and commercial driver safety. It's worth mentioning that SB 344 has garnered broad support from the trucking and commercial vehicle industries, which share the priority for driver safety training. California needs to take this first critical step and show its support for adequate commercial driver training standards. Thank you, Mr. Chair. Members would also encourage your aye vote at the appropriate time to bring this off suspense. Thank you.
Thank you so much. Is there any witnesses in support? individuals from the public in support, witnesses in opposition, individuals from the public in opposition. Department of Finance.
Finance is opposed to this bill due to the associated costs and the current structural imbalance of the motor vehicle account. Additionally, we feel this bill is premature as the federal commercial driver licensing regulations under development, which will come into effect in 2016.
Thank you so much. Questions or comments from the committee members? If not, would you like to close?
Just real quickly, with all due respect to Department of Finance, we believe we have addressed some of the financial concerns, fee-based support. The federal government has been working on this for 20 years. A constituent in my district, 25 years old, was the victim of a truck accident on Highway 17. The driver, by his own admission, had limited experience and training, was not equipped to handle the grades and the speed that his truck picked up. Not every tragedy provokes a legislative response, but in investigating this and winning the support of the trucking industry, our highways will be made safer, not just on Highway 17, but throughout the state. Safety for drivers as well as commercial truck operators who support these efforts. So again, at the appropriate time, I thank you for the opportunity to present this morning and would hope you'd be supportive when it comes up for a vote on suspense file. Thank you.
Thank you so much. The bill is on suspense, and we'll take it up in due course. Senator Block, you're up. You have SB 197 on consent and SB 589 do pass, and don't feel obliged to present on the consent item, please.
After consent, and I will present on SB 589, which allows disabled individuals who are under conservatorships to register to vote if, with a reasonable accommodation, they can communicate their desire to participate in the voting process. Basically, SB 589 does three things. Number one, it creates a presumption that a person has the right to vote regardless of conservatorship status. Number two,
we have a motion from Calderon and a second from Wood. Witnesses in support.
Members of the committee, we're almost on behalf of the City of California. We think this is an important reform that would do a lot to protect the voting rights of people under conservatorship, and so we urge your support. Thank you.
Great. Any other witnesses in support? Individuals from the public in support? Witnesses in opposition? Individuals from the public in opposition? Department of Finance.
Finance is neutral on this bill because it further clarifies the conservatees' voting rights and modifies the standard for determining when a disabled conserved individual is not competent to participate in the voting process. No cost to the Secretary of State, and any local government costs resulting from the mandate would not be reimbursable.
Great. Questions or comments from the committee members? Mr. Wagner.
Well, there will be a cost that we went over in the Judiciary Committee. They're looking at about 70,000 new court cases every 2 years as judges go through these applications. And so at a time when this legislature is very rightly concerned about funding of the judiciary, the idea of opening up the courts to these potential new cases strikes me as a significant cost that we ought to be cognizant of, and really ought be reason alone to vote against this one. I will say there was we don't have the testimony here today, but the supporters of this bill talked about their going and talking to the conservatees lawyers and said, well, when we raised this issue with them, all of these advocates just laughed at us. And they took that as absolute outrage that someone would laugh at the idea of these folks voting. And the reality is they laughed at it because they realized there's a reason these people are under conservatorship. And the reason they're under conservatorship is they in the vast majority of these 70,000 cases, the folks lack the capacity to vote. And therefore, we will only be opening the court and burdening the court for our judges to say, in essence, no, these folks, there's a reason that they're essentially wards of the state or under conservatorship, and so I see as a fiscal committee absolutely no reason to burden our courts with these new cases when, essentially by the admission of the opponents, most of the cases are going to get literally laughed out of court, like the lawyers for these people have already been laughing at the idea behind this bill. So I've got to urge a no vote for that reason.
Would you like to respond, Senator?
Very much so, yes. Respectfully, Mr. Wagner, as an attorney, probably understands hearsay rules. You weren't at the judiciary hearing. You're hearing his version of what happened at the judiciary hearing. I don't question his integrity, but just so you know, for those who were there, the bill passed 8-1 on a bipartisan nature out of judice. So his colleagues weren't as impressed as he was with whatever it is he's talking about. Want to make it real clear that this is just upholding the right to vote for folks with disabilities, and urge your aye vote.
Okay, let's have some decorum. Let's not let's behave ourselves a little bit. We appreciate you bringing this bill forward. We also appreciate Mr. Wagner's dissenting view, which he has every right to have.
Sure.
Any other questions or comments from the committee members? Seeing none, this bill is out on a B roll call with Chang not voting.
Thank you.
Thank you. Ms. Wolk.
Yes, good morning, Mr. Chair. I, too, have a 1-hour presentation on my consent bill.
Well, thank you. I appreciate that. SB 730 enjoys a due pass recommendation, and SB 793 is on consent. How would you like to proceed?
All right, Mr. Chair, 730 prohibits a train or light engine hauling freight in California from being operated unless it has a crew consisting of at least 2 individuals.
Move the bill.
Minor and absorbable costs. I ask for your aye vote, and thank you for that recommendation.
Mr. Chair and members, Barry Broad on behalf of the Teamsters. We represent rail employees, locomotive engineers. This is a basic safety issue consistent with the recommendations of both federal and state safety regulators, and I will note that the major derailments that we've seen in Philadelphia 2 months ago, 2 years ago in Quebec, were situations where the rail operator was allowed to and put one person in the cab, and those accidents, the one in Quebec took out half a town, the one in Philadelphia killed a number of people, and they very well might have been avoided had there been 2 people in the cab. The reason you have 2 people is the same reason you have 2 people in an airplane, pilot and co-pilot. And we urge an aye vote. There's no fiscal on this. Thank you.
Thank you so much. Any other witnesses' support?
Mr. Chairman, thank you for the opportunity to speak. I'm Tim Smith, State Chairman for the Brotherhood of Locomotive Engineers and Trainmen Teamsters Rail Conference. I would like to urge an aye vote on this particular bill. I think it's very important for safety in the state of California, and I do believe that the cost would be very minimal. Thank you.
Thank you so much.
Mr. Chair, members, Sarah Flocks, California Labor Federation, also in strong support. We have thousands of miles of railroad track in the state, and we're currently laying more, and this is an important safety measure for workers and the public.
Great. Just your name, position, and...
Michael Minkus on behalf of the California Public Utilities Commission. The Commission unanimously voted to support the bill that puts no cost redundancy in statute.
Thank you so much. Individuals for the public in support?
Mr. Chairman, members, Mike Anderson with United Transportation Union in strong support.
Witnesses in opposition. Come up to the front if you're a witness in opposition.
Mr. Chairman and members, Don Matty with BNSF Railway. We're opposed to this bill for several reasons. First of all, this is bad transportation policy. When you have different requirements across state lines and you're running a national rail system, you'll create additional problems with implementation that will result in poor safety and will also result in additional costs. There are other states that are considering legislation. For example, this year, there's another state that's going to require 4 crew. They haven't passed that piece of legislation, but you can see where this goes, requiring 2 here, requiring 4 there. You will not get shipping in 2 days or free shipping in the future if that four-person bill would pass. Second, this bill violates Proposition 17. This measure, this issue, came before the people in the past. Crew sizes were considered in the past, and the people voted to adopt Proposition 17 that said that the legislature should not be involved in crew consist decisions, that should be left to federal requirements and collective bargaining. Collective bargaining has worked. The people were right when they passed Proposition 17. Collective bargaining is a collaborative process. We work with our labor partners to determine how to implement safety across the board. That's worked very well. We have the best safety record in 2014, according to the Federal Railroad Administration, in history of the railroads. So the people were right. That is the reasons why we oppose this bill. Thank you.
Thank you so much.
Sandy George, representing Union Pacific Railroad. We have the similar concerns to what BN just testified to. I just want to note, too, this has been a part of the collective bargaining process for years. And currently, the collective bargaining requirements are to crew. This does not change the crew size for what the railroads are currently running across our rail line. So it does nothing to change the safety, and it does nothing to eliminate what is currently part of the collective bargaining process. But we think because it violates Prop 17, we're going to have to go to court to overturn anything if there are changes in the collective bargaining process in the future.
Thank you so much. Any other individuals from the public in opposition? Department of Finance?
Finance is neutral on the bill as it enhances safety and security on the state's rail system, and we estimate minor and absorbable costs.
Great. Questions or comments from the committee members? Hearing none. Senator Wolk, would you like to close?
Yes, very briefly. We disagree that this violates Prop 7. We had these discussions at the policy committee in depth. We disagree that it violates Prop 17. We think the public safety record is of concern. We think that this is an item for the legislature. Public safety is an item, and given the major train explosions or accidents in the last 5 or 6 years, even the Federal Railway Administration has issued 2 emergency orders and convened emergency sessions for new regulations. This is one of many items we need to do to ensure safety on the freight lines that are increasingly coming through California. I urge an aye vote.
Thank you so much, Senator Wolk. We have a motion by Eggman, a second by Calderon. This bill is out on a B roll call. Thank you so much.
Thank you very much.
Mr. Hernandez, you're up.